Jim, thank you for an excellent discussion on easements by prescription and estoppel, the location and scope of easements, and how easements may be terminated. Great synopsis on several topics that could have taken several hours in themselves to discuss. Now that Jim and I have covered the fundamentals of easements, including the definition, their basic attributes, the types of easements, and how they're terminated, we thought we'd spend a few minutes discussing some more advanced easement topics, or access topics. Since my specialty is title insurance and real estate issues related to title insurance, I wanted to discuss easements from a title insurance underwriting perspective. First, some special access or easement issues. Prescriptive easements and claims of adverse possession do not run against the federal or state government or any city or county. So if the access to land is by a private road or over a U.S. Forest Service road or any other federal land, then the right to use the road has to have been specifically granted or reserved by a specific easement. Access easements that cross a railroad also require a specific grant or a specific reservation of an easement. It's not automatic. And access to an island is another interesting easement topic. Since the owner has to cross the water, then the adjoining private land to get to a public road. It's wise to say that title insurers should be consulted before you try to close a transaction involving access over federal lands, railroads, or islands. But more than that, consult with your underwriting advisor or agent anytime you have an easement question. As Jim has said, we're here to help, and we take delight in helping to resolve easement and other real estate related questions. Title insurance ensures that there's access to a public road. What do you need to have a public road? It has to be dedicated and it has to be accepted into the highway system. And that means that there should have been a dedication to the Commonwealth of Virginia that's shown on a plat or that's specifically recorded in the case of condemnation and a taking, to prove that that road exists. Now, some old roads under the Byrd Act, which is pre-1932, were not specifically dedicated and specifically deeded. Those roads were accepted by the state and are used as public roads. They're still good public roads, but there was just a different system back before 1932. What happens if a public road that's used for access is abandoned and no longer publicly maintained? I'm not talking about a vacated road, which may be closed, and we know that the underlying fee goes to the adjacent property owners, reverts to those adjoining property owners. I'm talking about a truly abandoned road, which is merely no longer publicly maintained. When Jim and I were early in our careers and we were working on the title to the land for Water Country USA for our firm's client, there were several old abandoned roads, stagecoach roads, old abandoned county roads that ran across that land. The threshold issue is, has the road been truly abandoned? And for how long? Virginia Code 55.1307 codifies the maintenance obligations when a road has never been abandoned, but it's really no longer publicly maintained. So I commend that code section to you if you find yourself in that circumstance. The courts can determine and dictate what happens when a road is abandoned and no longer used by anyone. Every easement shows up in a title exam, and it should be addressed in a title policy. Most of the time, those easements are listed as Schedule B exceptions to that title policy, which means that the title insurer doesn't protect against the risk of loss due to those easements. Now, the easements might be broadly defined. They might talk about the location and the use and where they're located, and that's generally in commercial cases. For residential cases, it's pretty much just going to be a description based on a deed book and page number or an instrument number. The important thing is they're memorialized in the land records. As I mentioned before, they're recorded. They provide notice to the world that an easement exists. But what if there are easements that don't provide notice to the world by recording? What if they're just shown on a survey or an inspection report? Those easements, too, should be shown on a title commitment or a title policy as exceptions. And the practice pointer is, if you're looking at a survey and you see sewer grates or hydrants or transformer boxes, but you don't see any reference to any recorded easements for utilities, that's a signal that there are easements for utilities that must be determined. This is especially important in commercial cases where there are large paved lands that don't necessarily show what's under them, like in residential cases. Drainage easements are another good example of an easement that can be shown on a survey, but may not show up with a written instrument. So all of those items are shown on Schedule B of a title policy. Now, if you or your lender want to get rid of one of those exceptions, it's not enough to just come to the title insurer and say, hey, the lender doesn't like this, take it out. That's not going to happen. You have to come with an explanation as to why the easement doesn't apply, or a release of that easement that's going to be recorded in order to have it removed from the title policy or title commitment. Those old logging roads that I mentioned that Jim and I found, well, the title agent was able to rule them out with our help and a lot of diligent work so that they were actually not shown as exceptions on the title policy. But it was not an easy task, and it did take a long time. Title policies accept to rights of others to use of common easements, and rights of others to maintain, or how much those costs to maintain that easement may be shared among everyone using that easement. As I mentioned, if you want a title insurance policy to insure together with an easement, that's possible, but title to the servient and the dominant tract both have to be searched in order to insure together with that easement. We truly do enjoy, as title insurers, working with our attorney and our agent customers. Please don't ever be backward about calling and asking a question. The only question that is a dumb question is the question that you did not ask and that results in a problem for your client. So please don't feel awkward or backward about reaching out with a question. And now I'm going to turn things over to Jim to talk about some advanced litigation issues. Jim?
Well, Paula, I'm just grateful as you were telling the story about the abandoned roads you and I worked on that you did. I kept thinking you were going to go to the part where my Bronco shows up covered in mud because I had been on those roads trying to determine tree growth and measuring the circumference of trees, and was a little late for a meeting with my my truck covered in mud. But you didn't go there.
I didn't go there.
So thank you for that. As we mentioned earlier, my specialty, I guess, or my interest over the last 38 years has been real estate litigation, counseling, mediation, arbitration, and all the judicial settlement conferences, all the ways that litigation has evolved over the years. And one question that comes to mind is, how do you defend, for example, an easement by prescription suit? We've seen that there are 7 or so elements to an easement by prescription suit. It has to be exclusive, continuous, adverse for 20 years. So as I evaluate cases, a case comes in, step one would be to examine the title, get plats, get the deeds. You know you're looking for at least 20 years. The suit should outline those instruments and plats upon which they're relying. You'd want to get vintage photos. There are excellent vintage aerial photo sites out there. So there's a lot of detective work involved with defending. I often say you don't have to kill the suit 7 times, you just have to kill it once. So look for the weakest point. For example, a discovery that if you're defending that you'll want to send out, state all facts and applications of law to fact upon which you rely to show that your use was exclusive. Okay? Same question. Continuous, same question. Adverse, same question for 20 years. So I have a case right now that I'm defending in Prince George County, and they're not going to be able to show exclusive. So they might meet the other elements, but they're not going to be able to show exclusive. So zero in on the weak point. You don't have to defend. You're defending parts of the suit is one way to think about it. And then keep in mind that except for the adverse presumption, which is a important tool for a plaintiff. If they are using the land of another, they come into court with a legal presumption that cannot be rebutted by mere circumstantial evidence, but rather must be rebutted by affirmative evidence of permissive use, which may shift the burden back. But if it remains unrebutted, then the original presumption will stand, and the plaintiff literally can stand up at the beginning of the trial and say, I stand on my presumption, shift the burden to the other side can't rebut it, and you meet all the other requirements, then that shows the power of that legal presumption. Not everybody is aware of that presumption and how to use it. So, 20 years, not 19 years. Make sure you look for breaks, look for a time when the use was interrupted, and look to see how it started. Did it start by permission? There are a number of other things that we could talk about, but I want to shift to 2 other topics. Paula mentioned abandonment, and abandonment is really a question of intention. That sounds kind of fuzzy, but here, if you walk away with anything from our conversation about abandonment, remember this: mere non-use is not abandonment. You can have a road, in fact, I'm thinking of one right now, that where the pine trees have grown up for 20 years, it's impassable. But that does not mean the easement has been abandoned. It may seem that way from a common sense point. From a legal standpoint, it has not been abandoned. So when you're looking at abandonment, you're really talking about mere non-use coupled with acts that are affirmatively show that the easement has been abandoned and the user no longer uses it. For example, where a former dirt path has been allowed to grow up, all right, that is helpful in showing abandonment. But then it comes out, and there's a case right on point, that the dominant owner was asking the permission of the servient owner to use the road for 20 years. Well, that's permissive, but it also shows that the seemingly dominant owner or former dominant owner no longer felt he had an easement if he's asking for permission. So, and also abandonment, like an affirmative easement, prescriptive easement, easement by necessity, implied easement, easement by estoppel, all have to be shown by clear and convincing evidence, somewhere between preponderance of the evidence and, beyond a reasonable doubt, wherever that kind of land is in the middle. Same thing for abandonment. You have to show abandonment. If you have to show the easement by clear and convincing, you have to show the abandonment by clear and convincing. And then the final point I'll make on kind of these specialized issues or some particularized issues relating to litigation and how they play out in real property litigation is one that a lot of folks are not aware of. Is there a cause of action under Virginia law for tortious interference with an easement? You've maybe, if you've been in the game for a while, then you've heard of tortious interference with contract, tortious interference with business expectancy. There are, in fact, cases, 3 or 4 cases that talk about a separate and distinct cause of action for tortious interference with easement, and a couple of sites, and then we're going to wrap up. 224 Virginia 206, 57 Virginia Circuit 332, 248 Virginia 142. As Paula and I have tried to emphasize, we've been colleagues. We bounce things off each other over the years, and certainly feel free to call both of us. We're here to help. We mean that. We'd love to be a sounding board and pitch in and help. And as I said before, we're all in this together, and let's get by with a little help from our friends. Talk to you later.